Senate is back in order. We are on order of business 9. Senator Cannizzaro.
Thank you, Mr. President. All right. I move that Senate Bill number 35 be taken from its position on general file and placed after Senate Bill number 343 on general file.
If there are no objections, so ordered. Senator Cannizzaro.
Thank you, Mr. President. I move that Senate Bills numbers 310, 321, 323, and 328 be taken from their positions on general file and placed at the bottom of general file.
If there are no objections, so ordered. Senator Cannizzaro.
Thank you, Mr. President. I move that Senate Bills numbers 318, 326, and 379 be taken from their positions on general file and placed on the Secretary's desk.
If there are no objections, so ordered. Senator Cannizzaro.
Thank you, Mr. President. I move that Senate Bills numbers 39, 133, and 352 be taken from the Secretary's desk and placed at the bottom of general file.
If there are no objections, so ordered.
That concludes order of business 9.
Order of business 10.
Assembly Bills. Assembly Bill 73 by the Assembly Committee on Education provides right of public school pupils to wear certain adornments at school graduation ceremonies. Refer to Education. Assembly Bill 120 by Assemblyman Hafen provides to certain provisions governing voluntary health care service. Refer to Commerce and Labor. And Assembly Bill 154 by Assemblywoman Peters, etc., and Senator Krasner provides for the regulation of living donation of birth tissue. Refer to Health and Human Services. End of Assembly Bills.
Order of business 13, general file. Okay, we're back on order of business 10. Senator Lang.
Thank you, Mr. President. I move to refer AB 73, AB 120, and AB 154 to the committees as listed on the agenda at your desk.
Thank you. If there are no objections, so ordered.
That concludes order of business 10.
Okay, order of business 13, general file.
Senate Bill 314, introduced by Senator Lang and Assemblyman Carter, provides its provisions relating to energy storage systems. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 7, end of Section 7, end of bill.
Senator Lang.
Thank you. Sorry about that. Thank you, Mr. President. Senate Bill 314 requires the Public Utilities Commission of Nevada to establish biennial targets for certain electric utilities in order to provide the greatest benefits to customers in relation to the cost of procuring energy storage systems. The bill requires licensed individuals to install electrochemical energy storage systems in conformance with certain standards. Finally, the bill authorizes the provider of a training program for installation of electrochemical energy storage to request a joint interim standing committee on growth and infrastructure to review the program for the committee and to include recommendations regarding the same in its final report. Provisions related to the biennial targets for procurement of energy storage systems are effective on July 1, 2024. All other provisions are effective upon passage and approval for the purpose of adopting any regulations and performing any other preparatory administrative task, and on October 1, 2023 for all other purposes. The definition of facility for the storage of energy from renewable generation expires by limitation on June 30th, 2049.
Thank you. Are there any remarks from the floor? Senator Hansen.
Thank you, Mr. President. I reluctantly have to rise in opposition to Senate Bill 314 simply because some of the amendments that were requested apparently have not been approved, and that is the way the wording of the bill is currently. Frankly, if you're not a union contractor, you're going to have a hard time getting this licensing. And there was an attempt to try to make sure that non-union contractors would also have an ability to get this kind of licensing, and it was never amended in the bill, so I'm going to have to urge everyone to vote no on it at this point. Thank you, Mr. President.
Any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 13, the nays 8. SB 314 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 333, introduced by Senator Neal, revises provisions relating to virtual currency. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 18, end of subsection 2, end of bill.
Senator Neal.
Thank you, Mr. President. SB 333 establishes provisions governing virtual currency and virtual currency business activities with or on behalf of a resident of the state. The bill requires virtual currency business to register with the Commissioner of the Division of Financial Institutions before engaging in any activity in the state. The bill creates the virtual currency recovery account with the state general fund to fund or provide to eligible persons restitution for fraud, abuse, and exploitation as caused by virtual currency businesses.
Are there any remarks from the floor? Senator Severs-Gansert.
Thank you, Mr. President. I rise in support of Senate Bill 333. Right now, we don't really regulate cryptocurrency. Neither does the federal government. And much of what is in this bill is what we use to regulate banks and other types of savings associations. Thank you.
Are there any further remarks from the floor? Seeing none, Secretary, call the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 17. The nays are 4. 333, SB 333 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 334, introduced by Senators Spearman, et cetera, revises the provisions relating to energy storage systems that are used to meet certain biennial energy storage targets. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 3, this act becomes effective upon passage and approval. End of bill.
Senator Spearman.
Thank you, Mr. President. Senate Bill 334 authorizes an energy storage system that is commercially available technology which is capable of retaining, storing, and delivering energy using only green hydrogen to meet existing biennial storage targets. The effective date of this bill is upon passage and approval. Side note, green hydrogen is produced through a certain process that is completely powered by renewable energy, not water.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 21, nays are 0. SB 334 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 335, introduced by Senator Orenshaw, revises provisions regarding real property. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 23, end of Section 23, end of bill.
Senator Orenshaw.
Thank you, Mr. President. Senate Bill 335 authorizes the Justice Court to create an eviction diversion program and provides guidelines for participation in that program. If the court assigns a tenant to such a program, the court must stay a pending action for summary eviction for up to 60 days after the tenant files an associated affidavit and must dismiss the pending action if the tenant pays the amount of rent in default or surrenders the premises before the stay expires. The bill also authorizes the tenant to claim as an affirmative defense to certain eviction proceedings that the tenant has a pending application for rental assistance or that the landlord has refused to participate in the application process for or accept such rental assistance. The court must stay the proceedings for up to 60 days upon the assertion of such an affirmative defense unless the landlord receives an exemption from the court. The landlord may file a motion to rebut the tenant's affirmative defense, and if such a motion is filed, the court may hold a hearing or maintain the stay. Under certain circumstances, the court must dismiss the eviction proceedings upon the granting of the application for rental assistance and receipt of the rental assistance by the landlord. However, these provisions do not apply if the rental assistance received by the landlord does not cure the default of the tenant. If the tenant proves certain claims, the court must deny the eviction. The court may award damages if an eviction is denied for landlord's refusal to participate in the application for or accept rental assistance. Further, a tenant or landlord may, in a separate cause of action, recover certain damages if the other party acted in bad faith.
Are there any remarks from the floor? Senator Stone.
Thank you, Mr. President. Good evening, colleagues. First, let me say I applaud the author for his genuine concern for people that are at risk of being evicted, and I share that concern. Landlords like myself were not allowed to evict during COVID as a result of the executive order by former Governor Steve Sisolak, nor would we have done so even if we were legally allowed to. Let me state for the record that I've never evicted a tenant in the 5 years that I've been a landlord here in Nevada. We've never lost a tenant because we raise their rent. We don't see our tenants as numbers, but rather as human beings that need help during challenging times. We've always worked with CHAPS. If they have an application for rental assistance, we always stay any type of effort to evict people. Prior to COVID, Nevada had no problems with the process to pursue eviction if a tenant didn't pay their rent or poses a public safety issue and they have to be evicted. The process is not an abbreviated one that has the appropriate noticing requirements and time for the tenant to mitigate their dire circumstances. First, a tenant is usually not a month behind, but usually many months behind before they're served. Given a 7-day notice that they can respond to, and after that 7-day notice, it still takes weeks for a constable to come out and escort the delinquent tenant out of the unit. Hence, there's already sufficient time for a tenant to cure the defaults if it is in fact curable. This bill will cause greater delays and legal costs for a landlord that may need to evict a tenant. These unnecessary higher costs are ultimately passed on to the end user, the tenants, which is required by the language in most leases, including mine, with regards to the prevailing party to be awarded legal costs to enforce the provisions of the lease that they signed, a contract between a tenant and a landlord. This will further hurt the people the author is trying to protect. The present system today works for the benefit of the tenant as well as the landlord. Everyone should be held accountable for their obligations under a lease, a legal contract, between a landlord and a tenant. If the tenant follows the rules and pays their rent, there should be no issues. If not, there must be a streamlined legal avenue for landlords to have, and for these reasons, I respectfully oppose SB 335.
Are there any further remarks? Senator Orenshaw.
Thank you, Mr. President. And again, I respect the comments made by my colleague from Senate District 20. I have to respectfully disagree. I think we've amended the bill quite a bit. The bill in this amended version provides 60 days. It's not a blanket stay on eviction. Someone has to provide an affirmative defense that their bona fide attempt to seek rental assistance, the court can get information about whether that's still active, whether it's still going. There are damages that can be awarded against the tenant if the affirmative defense was sought in bad faith. Our part of the state down in Clark County, we have a homeless situation like we have never seen so many unhoused of our brothers and sisters. And if in 2 months a program like this can help people get the rental assistance they need, make the landlords whole, cure the deficiency, I think it really benefits all of us in terms of trying to keep people housed and try to make landlords whole. I urge its support.
Are there any further remarks? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. Yeses are 12, the nays are 9. SB 335 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 336, introduced by Senators Orenshaw and Stone, revises provisions relating to the regulation of certain healing arts. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 7, end of subsection 2, end of bill. This bill requires a 2/3 majority vote.
Senator Stone.
Thank you again, Mr. President. Senate Bill 336 provides the statutes governing the practice of dentists, nurses, osteopathic physicians, and assistants, podiatrists, and optometrists do not apply to any person permitted to practice any other healthcare profession who does not within the scope of their authority. These exemptions apply to any conduct by a healthcare professional before, on, or after the bill's effective date which has not been adjudicated by a regulatory body governing the practice of dentists, nurses, osteopathic physicians, and assistants, podiatrists, and or optometrists. In addition, the bill requires such regulatory bodies to terminate any investigation or disciplinary proceedings for conduct that is outside the scope of the regulatory body. In addition, the bill requires the State Board of Nursing to issue a certificate of registration to practice as a certified registered anesthetist to a qualified applicant and adopt regulations governing the practice of such nurses. Further, the bill authorizes a certified registered nurse anesthetist to order, prescribe, possess, and administer controlled substances, poisons, dangerous drugs, and devices to treat patients under the care of a licensed physician when working in a critical access hospital. This bill is effective on passage and approval for the purpose of adopting regulations and performing other preparatory administrative tasks on January 1st, 2024 for all other purposes. Thank you, Mr. President.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 21, the nays are 0. SB 336 has received a constitutional two-thirds vote and is declared passed and ordered to the Assembly.
Senate Bill 343, introduced by Senators Canizaro, Dondero, Lupe, and Pazina, revises provisions relating to fentanyl and derivatives of fentanyl. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 14, this act becomes effective on July 1, 2023. End of bill.
Senator Canizaro.
Thank you, Mr. President. I rise in support of Senate Bill 343, and I'm going to actually talk about this bill and refer to another bill that is coming up on our agenda, Senate Bill 35, because the two bills are companion bills of sorts. So Senate Bill 343 establishes a crime of low-level fentanyl trafficking, which provides that anyone who knowingly or intentionally sells, manufactures, delivers, or brings into this state, or is knowingly and intentionally in possession of illicit fentanyl, derivatives of fentanyl, or mixtures containing fentanyl or their derivatives, is guilty of such trafficking if the quantity involved is 4 grams or more, but less than 14 grams. This bill also has in it provisions that keep intact our Good Samaritan laws, which was an issue that was addressed when this bill was initially heard in our Judiciary Committee, which would provide that if somebody is experiencing an overdose or is with somebody who's experiencing an overdose and they call for medical attention, that they cannot then be prosecuted, because what we want to see is that they are actually reaching out to save someone, especially when fentanyl is concerned. Senate Bill 35, which I mentioned is a companion piece to 343, addresses some other aspects of fentanyl and how we are attempting to tackle what is an extremely large crisis in our communities. And I recognize that there are legitimate concerns about how it is that we will be addressing fentanyl use in our communities and to ensure that we are not overly criminalizing people who might be in mere possession of. What I would note is that mere possession of, in any amount of fentanyl, is currently a felony in the state of Nevada. And what we are attempting to do with trafficking laws, which we do in our trafficking laws for all the other types of controlled substances that are regulated, is to say that when you are manufacturing, selling, bringing into the state, or in possession of such a significant amount, that is not for personal use, and that crosses a threshold for someone who is actively working to distribute or profit from putting these substances into our communities. Certainly, this bill will not eradicate all controlled substance use, but what we are seeing in our communities is an overwhelming increase in the number of individuals who are taking fentanyl, who are distributing it into our communities, and who are having the effect of poisoning and killing many, many, many people, most of whom are young kids. And most people who experience a situation where they come into contact with fentanyl are lucky if they make it to an emergency room and that they don't find themselves in a situation where they are dead. And that is just the type of substance that fentanyl is, and that's why I support 343. I know that the thresholds are lower, but the reasoning for that is that it is such a very small amount of fentanyl that can cause such damage. And so while fentanyl possession is already a felony, what this is seeking to do is to allow an additional tool for those who are in possession of an extraordinary amount of fentanyl, because they're not using that for personal use. They're using that to distribute into communities. And there has to be an answer that isn't, we just can't do anything for families who have so many loved ones who are dying from an epidemic in our communities. And so I urge my colleagues' support of Senate Bill 343. I will speak to Senate Bill 35, but wanted to mention that they are sort of companion bills as they address a multitude of factions and are attempting to strike the right balance between making sure that we can utilize law enforcement to address what is an extremely dangerous market that is very present in our communities, while at the same time recognizing that there is also an accompanying opioid epidemic that is sort of fueling this. And so how do you balance those two things? I think between preserving the Good Samaritan pieces and increasing the ability for us to deal with fentanyl traffickers in our communities is striking part of that right balance and along with Senate Bill 35, but I would urge my colleagues' support for Senate Bill 343.
Are there any remarks from the floor? Senator Stone.
Thank you, Mr. President. And first, let me say that I applaud our majority leader and I applaud our Attorney General to address this fentanyl crisis that we're having. I'm sure the fentanyl crisis has touched probably most of all of us. I've lost a couple of friends who had children that came from various socioeconomic groups that tried the opiate for the first time, and there's no second chances with fentanyl. The intent of this bill is to get traffickers of fentanyl, but may unnecessarily target people that are using fentanyl. Again, we saw over 80,000 people die of fentanyl intoxications last year, and probably those numbers are going to be the same, if not more, in the coming year. The bill establishes this particular one, and I'm going to be talking to SB 35 because they're basically both the same bills except for the level of crime, low level, mid level, high level of trafficking. My concern is that if you look at the bill language, it talks about illicitly manufactured fentanyl, any derivative of fentanyl, or any mixture which contains fentanyl. And it's that amount, that weight, that includes not just fentanyl, but maybe a filler, lactose or cellulose, that can push somebody into being a trafficker that's not a trafficker, that's probably a user. Those that have mixtures of fentanyl are usually the end users. That a user doesn't get pure fentanyl. And the reason why is, many of you heard it, as little as 2 milligrams can kill you. So you're looking at like 8 grains of salt. There's no way to sell 8 grains of salt to somebody and say, go ahead and get high on this. So what these illicit traffickers do at a higher level is they cut the fentanyl. So it's like taking a pea, if you will, and imagine a pea being a food coloring, a ball of food coloring, and you're incorporating that into 5 pounds of flour. Now, to get that done efficiently is something called geometric dilution, which we use in compounding pharmacies, but these illicit distributors, purveyors of fentanyl aren't that scientific. So you'll get some people that will get samples of fentanyl in capsules or tablets that will say, this stuff didn't do very much for me at all. And then you get other people that get the capsule or the tablet and they die. They die because they go into respiratory depression. By definition, fentanyl that is cut or diluted with an excipient like lactose or cellulose can be considered a mixture of fentanyl. So illicitly, you'll see fentanyl coming in tablets or coming in capsules. And I'll give you an example. An addict may have bought a 1 milligram fentanyl tablet or capsule or a bag of powder, which are mixtures of fentanyl. Tablets, like the size of a Tylenol tablet, weigh about 4 grams, which is equivalent to 4,000 milligrams. So if you have 1 milligram of fentanyl in there, you've got 3,999 milligrams of lactose or cellulose, or maybe even another drug, but you are going to be penalized as a trafficker because you're having 4 grams to 28 grams. If someone just had 3 tablets of this 1 milligram fentanyl, the total amount of fentanyl is 3 milligrams, with the mixture weight is 12 grams, which is the basis for this crime. This bill refers to the total weight of the product collectively, including fentanyl and the inactive ingredients, so the other drugs that are not related to fentanyl could also be included. So this person would be found guilty by this bill of low-level trafficking by having 3 tablets, 12 grams, that only has 3 milligrams of fentanyl, which is a Category B felony. I don't really believe that that's the motivation of the author. A Category B felony is not less than 1 year and a maximum term imprisonment of not more than 6 years and a fine of not more than $50,000. Well, again, I don't believe that it's the author's intent to reignite the war on drugs with this bill. It will have the unintended consequences of doing so. Users will be convicted of low-level trafficking as a result of their purchase and consumption of fentanyl mixtures to satisfy their powerful addiction. So then if we, just quickly, if I may move on to just SB 35, mid-level 14 to 28 grams is the equivalent of 7 of those 1 milligram fentanyl tablets, which is a Category B felony. And 28 grams is the equivalent of just 8 of these tablets. And for that, they can get 20 plus years in prison for being a user trying to satisfy a habit which I think many of us consider to be more of a health problem than a criminal problem. So we better build more prisons, because if this bill is passed without any amendments, the old war on drugs will be pale in comparison to the tens of thousands that could get life sentences for the crime of just being addicted to opiates and having a small amount of fentanyl mixtures that are purposely cut to not kill the addicted soul. The jail and prison rehabilitation program will be unaffordable to accommodate so many prisoners. I would be honored to work with the authors to amend these bills that do little to go after the traffickers, but instead criminalize opiate users that have health care related problems. I will support this bill today, but I hope that the author will amend the bill, which, if left unamended, again, will restart the war on drugs against vulnerable populations of Nevadans. I don't believe that to be the intent of the author. I would be honored to work with the authors to try to make sure that that doesn't happen. I do urge a yes vote on these bills. Thank you.
Senator Severs-Ganser.
Thank you, Mr. President. So I think we can agree that the Majority Leader and the Senate from District 20 and I, and probably everyone in this room, violently agree that we need to do something about fentanyl. It's killing so many people, and I know there's been other, and just to kind of review, sort of in a different way, right now the state does not have any penalties unless you have 100 grams, 100 grams. That's a Schedule I drug, just blanket Schedule I drugs. This bill proposes 4 grams, as does the other bill that's on our agenda. We had another bill that was at 4 milligrams, right? So 4 milligrams times 1,000 is 4 grams. As little as 2 milligrams, 2 grams of salt is lethal. So the toxicity is enormous, but the flaws in the bills that we have before us, which I'm still going to support because we have to do something and it's extremely complex, does not consider the intent to sell. So when I talk to the Metro, Las Vegas Metro, when I talk to DA's offices, and when I talk to law enforcement, the intent to sell is a critical piece, and I believe that's what my colleague from Senate District 20 was talking about, not just having pills on you, but the intent to sell. There was also discussion about fentanyl is always mixed, because straight fentanyl, again, 2 milligrams, which is 2 grains of salt, will kill you. So it's always mixed. So we have to be able to differentiate how much fentanyl is in a pill, how much the pills weigh, if we want to prosecute them with category A, B, C felonies, or we want to differentiate between those who are using the drugs versus selling the drugs. And when I talked to the DA's office and other law enforcement, I was thinking about the kids that go to festivals and they get handed some pills and they think, oh, I'm just going to try this once, and then it's laced with fentanyl, right? So we don't want to put them in prison for a long time, but we want to make sure it's not in their hands, which goes back to the intent to sell. So I think at some point in time, these bills, I'm very hopeful these bills, or a bill comes out of here that is amended to make sure that we include intent to sell and also lower the amount of fentanyl. Again, we're at 100 grams. This is going to 4 grams. Lethal is 2 milligrams, 2 grains of salt. And there's been discussions about how we can't differentiate what's really in a pill. Like, we can weigh them, but we don't really know how much is in there. Just so everybody's aware, as of March 24th of 2023, the state of Nevada and various municipalities have received $347 million from the different companies that have been sued through National Settlement Agreement and also the state of Nevada. Of that, about $75 million has been spent on attorneys. So the net is still over $300 million. I think we can afford equipment to figure out how to test and how to differentiate the weight versus what fentanyl is actually included in the drugs, to make sure that we prosecute those who truly need to be prosecuted and we don't capture those who are mistakenly using it or have an addiction problem. So again, I think we all violently agree we need to do something. It's just how we do it. It's extremely complex, as I'm sure everybody's figured out by now. So again, I rise in support, and I hope hopefully we can amend some legislation before we end the session to make sure that we can get fentanyl off the streets. Thank you.
Are there any further comments on the floor? Seeing none, the Secretary will open the roll. Senator Spearman? Anyone who want to change their vote? Seeing none, the Secretary will close the roll. Yeses are 15, the nays are 6. SB 343 has received a constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 35, introduced by Health and Human Services, revises provisions relating to controlled substances. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 13 into Section 13 into bill.
Senator Cannizzaro.
Thank you, Mr. President. As I mentioned, Senate Bill 35 is a companion piece brought by the Attorney General's Office to Senate Bill 343. And the two bills work together to sort of address, again, multi-facets of what we are seeing and what it is clear many people are acknowledging is, in fact, an epidemic and a crisis. So Senate Bill 35 establishes crimes of mid-level and high-level trafficking for illicitly manufactured fentanyl and the derivatives thereof. I would note that trafficking, yes, can include possession, because oftentimes what you will run into, and as someone who worked in law enforcement for over a decade, what you will run into is individuals who have a large quantity, but what you don't find is an O sheet, a scale, an undercover officer who is engaging with that particular person who is looking to sell that particular substance, and no tools to address that issue. With 28 grams or more of fentanyl, someone who has that level of fentanyl is using it not for their own personal use, even if it is mixed with another substance. And so that's the purpose of trafficking laws, to be able to get at those individuals. And I would also note that when you do have intent to sell, I think sometimes we speak in this body like maybe there is not any sort of tool or ability to acknowledge that. Trafficking includes the sales portion of that. Selling a controlled substance is already a Category B felony in the state of Nevada, sale of a controlled substance. You can also have possession of a controlled substance with intent to sell. That is also a felony in the state of Nevada. What this is seeking to do is to get at a particular subsection of criminal activity that is putting these particular controlled substances into the community. And when we talk about illicit manufactured fentanyl, what also we are talking about is the idea that fentanyl, as we know it and how it is addressed in the current Nevada revised statutes, is medical grade fentanyl, which you're going to find in hospitals and other medical facilities that is used for pain management with doctors. That is not what we are seeing in the streets. What we are seeing and what we refer to as fentanyl is a fentanyl derivative. It's something that is illicitly manufactured, that you're not getting from a hospital, that is coming into our communities in a different fashion, which is why this is not a disciplinary measure for doctors. Why this is something that is seeking to go further. So I wanted to just clarify a few pieces of that, because we can't look at these bills in a vacuum without looking at the rest of our Nevada revised statutes and without looking at how law enforcement can address some pieces of this, but not a specific piece that we are encountering, and that is the purpose for these particular bills. And I think for other bills that also include very similar levels and very similarly are trying to get at some of the pieces of this. What Senate Bill 35 also does that I think is extremely important is that it does allow for the implementation of medication-assisted treatment programs in prisons and jails for offenders who have substance use disorders. We cannot talk about making sure that law enforcement has the right tools if we're not also willing to address the problems associated with why we are encountering those issues in our communities. And medication-assisted treatment is a huge piece of that. And so if we are going to talk about how we are trying to tackle some of these problems. And with individuals who have a substance use disorder, then there has to be a place for also having a conversation about treatment. And that is one other piece that Senate Bill 35 seeks to address. And so I think we would be remiss to look at one little piece of this and somehow argue that we're not trying to take a multifaceted approach, or that somehow we can ignore the other statutes that exist, because I think to do that maybe makes it a little easier to criticize the policy that is in Senate Bill 35 and that we just talked about in Senate Bill 343 as they sort of address that problem in a variety of ways. And so I would urge my colleagues to support Senate Bill 35, as it is a companion piece of legislation to Senate Bill 343, and hope that I have clarified some of the pieces of the debate this evening. Thank you, Mr. President.
Are there any remarks from the floor? Senator Stone.
Yeah, thank you again, Mr. President, and I really appreciate the majority leader's leadership on this, especially with derivatives. So if you have carfentanil, as an example, that is a commercially available drug usually used in veterinary medicine. It's 10 times stronger than fentanyl, even more dangerous. And so if you look at these two bills, I think a very simple fix to some of the issues that I was describing before as far as the bulk weight is that when you talk about illicit fentanyl, maybe putting illicit pure fentanyl or illicit pure fentanyl derivative, I think that would ensure that the person that is in possession of the pure substances is in fact trying to traffic it. Also, my wonderful colleague, our minority leader, talked about the funds that are available to be spent, opiate settlement funds. And the machine that she was talking about was a gas chromatography machine. And they run about $120,000 each. We don't have any of those machines here in Nevada, surprisingly. We learned that during our sessions. We could and we should buy two of those machines, one for the Southern Crime Lab, one for the Northern Crime Lab, so that we can appropriately analyze these samples to make sure that somebody is not just a user versus a trafficker. Again, I support these bills. I support the medical intervention in the prison side to try to help people wean themselves of these highly addictive substances and hopefully get them on the road to sobriety and leading a good life. I think these bills are great bills. There was no criticism meant other than I think there's unintended consequences that goes after people that we shouldn't be going after. We need to go after the traffickers, and we need to get help for the people that are using and not have raise the penalties, if you will, on people that are just innocently trying to satisfy an addiction for which they are horrifically addicted to opiate-type products. So, again, I urge your yes vote on this.
Any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 15. The nays are 6. SB 35 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 344, introduced by Senator Neal, revises provisions governing education. The people of the state of Nevada, represented in Senate Assembly, to enact as follows, Section 1 and to Section 1.
Are there any amendments?
There are none. Section 17, this act becomes effective on July 1, 2023. End of bill.
Senator Neal.
All right. Thank you, Mr. President. SB 344 prohibits principals, organizational teams, and boards of trustee of large schools from impeding or discouraging public comment at certain meetings. The bill also requires large school districts to undergo an audit every 6 years, regardless of the availability of money from the legislature. Further, after being hired, a superintendent and a school associate superintendent must research and be evaluated on the Nevada education laws and regulations, as well as certain district policies and programs. Additionally, 344 set forth education requirements for license for substitute teachers. The bill also allows certain employees to provide leave
to an employee who is a parent or legal guardian of a child to attend meetings of the school or school district where the child is enrolled, and an employee in a public service may be similarly granted such leave. Finally, SB 344 prohibits governing bodies of counties and cities from sponsoring, operating, and expending money to support a charter school unless their program was in existence before July 1, 2023.
Are there any remarks from the floor? Senator Buck.
Thank you, Mr. President. So let me paint a picture for you. Downtown Las Vegas, many of the schools in that area are 1- and 2-star schools. So to put that into perspective, that's 8 to 25% proficient in math or reading. And so City of Las Vegas got together and were like, I am frustrated with the education system in our city. And they helped create a foundation, and the State Public Charter School Authority authorized the opening of Strong Start Academy. Now, the demographics of this school is about over 80% ELL, 100% disenfranchised, free reduced lunch, about 15% special education students, the very children that this body continues to leave behind in failing schools. Strong Start Academy is only one out of a few of the only bilingual schools for Latino students. Now, I don't know about you, but I am frustrated with the lack of innovation and progress within CCSD. I'm frustrated that this body has done nothing to address those schools that are failing our students in the city of Las Vegas year after year after year for over a decade now. You want to leave these children, these failing schools, these schools that are failing our kids and these children behind, and then you want to attack the very hope that these kids have in this school that's actually making progress for them and is a beacon of hope in Las Vegas, downtown Las Vegas, where many of the schools are failing our kids. And so I ask that this body vote no on this bill for many reasons, and it just cut me off.
Senator Buck, I didn't cut you off, did you? Are you done speaking? Okay, all right. Senator Neal.
Thank you, Mr. Speaker. I rise in support of SB 344. So we have done a lot for actual students of color. We passed Zoom, we passed Victory. This particular measure in this piece has a lot to do with legislation that came forward in 2015, which allowed a city to use their redevelopment dollars in order to create an early K program, meaning pre-K. They asked for legislation in order to move forward to create pre-K programs because there was a gap within CCSD schools in regards to pre-K programs. The legislative authority that was given to them said wraparound services and early childhood education. That current statute is still in play under NRS 279, which is the redevelopment law. And then the city decided that they would then, or they're seeking now to expand and do K3, K5, K12. Number one, it's not legally authorized. Number two, it is not in the best interest for cities to run schools. There is no data that actually supports the movement of cities starting to run schools. We already have a large school district. We already have charter schools. We have charter schools under the charter authority. We do not need cities to actually engage in the work of education. If they would like to continue in the work where we're doing the gaps, such as early education, such as using their dollars in order to build into the schools, to do wraparound services, no problem. Those are currently the needs that are established in law, Those are the needs that are being carved out in this bill. It is grandfathering in the existing activity that is currently happening with the city of Las Vegas. It is not removing it, but it's not allowing them to continue to grow into a space that, number one, they don't have the authority to grow into. Number two, they didn't ask for that authority to expand. And so I understand my colleagues' passion for education, but I also have a passion for education too. I have a passion to make sure that the district runs effectively based on what it's supposed to do, which is serve kids, educate kids, and actually provide the educational environment that is their role. It is not the role of the city. The role of the city is to provide sewer services, other municipal services that they are set up to do within their charter. Education is something that they wanted to engage in. If they want to engage in wraparound services and add additional dollars and human support into the existing schools that's being paid for by tax dollars, no problem. But currently in law, NRS 279 does not allow them to go beyond what they're doing, which is the early K wraparound services, which they're currently doing. And so I will close my remarks with that.
Senator Buck.
Thank you, Mr. President. So this is authorized by the State Public Charter School Authority, so tax dollars go to the school. And I believe in the hearing, the Las Vegas city said that they don't run the school. They help give some funding to the foundation, maybe. I don't know that for sure. But I know that the State Public Charter School Authority authorized the school.
Senator Neal.
Thank you, Mr. President, and this will be my final remark. So I miss the opposition, but one thing that I do know is that it is not transparent how the dollars work for this particular charter schools that are being run. It's not clear what the city dollars are, the RDA dollars that are going into the school versus the per pupil expenditure. That question has been asked, and the way that it's been seen is that it's a blend, but it's never been clear on what pays for what, number one. Whether or not the redevelopment dollars that are literally set apart for blight in that community, which in West Las Vegas, they have severe blight. There have been historical problems of fighting for 30 years in order to remedy the blight that has been in those historical communities. And now those dollars are being expended for education when we already have dollars for education. So my argument was, and still is, from 2015 till now, is that the RDA dollars should have been set aside to remedy the blight in housing, homelessness, and other things that were going on in the city, but yet they are using and diverting their dollars to run an early child care program. I have grandfathered in that early child care program in this bill, but I want to make certainly clear that the RDA under NRS 279 should not cross over into NRS 388, 385. Those schools should remain in place. However, the city needs to spend their money on the existing blight that is going on in that area and in that district, which happens to be nested in Senate District 4. So I think I have clear knowledge on my own district that, number one, I've served since 2011. Number two, that the transparency around the money has never been indicated, nor has it been clear on what city dollars cover what services and how.
Are there any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 13, the nays are 8. SB 344 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 346, introduced by Senator Spearman, revises provisions relating to motor vehicles. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 6, end of subsection 3, end of bill. This bill requires a two-thirds majority vote.
Senator Spearman.
Thank you, Mr. President. Senate Bill 346 authorizes certain transactions to be conducted through an electronic branch office of the Department of Motor Vehicles. The bill revises requirements related to certificates of registration and certificates of title of a vehicle and authorizes electronic signatures for those documents. The bill requires the DMV to design, prepare, and issue special license plates for wholly electric-powered vehicles and reduces the fees to issue and renew such license plates. Finally, the bill authorizes a licensed driver to operate an autocycle upon a highway. The bill is effective upon passage and approval for the purposes of adopting regulations and performing preparatory administrative tasks, and on January 1st, 2024, for all other purposes. However, provisions relating to autocycles are effective upon the date the director of the DMV notifies the governor and the director of the Legislative Council Bureau that the department has sufficient resources available to carry out those provisions. Some background information: an autocycle means a three-wheeled motor vehicle that is designed with two front wheels and one rear wheel, has a steering wheel or handlebars, has safety belt for the driver and each passenger, uses foot pedals to control braking and acceleration, does not require the operator or passengers to straddle or sit astride, and has been manufactured to meet the federal safety requirements for a motorcycle. And just as a side note, I did check with Mr. Sean Savers to make sure that what we're talking about here, they're trying to adjust what they're currently doing with the reality with respect to the fees. So there's not, quote, an increase in fees. It's just bringing the fees, or bringing the legislation in line with the fees. Thank you.
Are there any remarks from the floor? Senator Titus.
Thank you, Mr. President. Originally, I was going to be in opposition to this bill, but I do support this bill and encourage my colleagues to vote yes. As the bill was written, and it was a little tough to decipher how the wording was, it originally looked like they were going to decrease and give a credit or a lower fee to a registration or a plate if it was an electric vehicle, when in reality they're just changing where the fees are. And so the electric vehicle will still have to, the plate will still have a charge. I do want to submit to this body at some point, we do have to look at these electric vehicles and the use on our highways, since they're not paying taxes on their fuel tax. So having said that, I am supporting this bill. Thank you to the sponsor.
Any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 21, the nays are 0. SB 346 has received a 2/3 vote and is declared passed and ordered to the Assembly.
Senate Bill 349, introduced by Senator Flores, revises provisions relating to document preparation services. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1 and Section 1.
Are there any amendments?
There are none. Section 9, this act becomes effective on July 1, 2023. End of bill. This bill requires a 2/3 majority vote.
Senator Flores.
Thank you, Mr. President. Senate Bill 349 requires a document preparation service to request an amended registration for the Secretary of State under certain circumstances, establishes advertising requirements, and authorizes the suspension or revocation of a registration or civil penalties for certain violations. A document prep service may use the term Department of Motor Vehicle or DMV in advertisement if the term is immediately followed by the language that clearly indicates the document preparation service is a third-party business and not affiliated with the department. In addition, the bill establishes notification and registration requirements and prohibits a person from misrepresenting themselves as a document prep service or submitting an application for registration that contains substantial and material misstatements or omissions of fact.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 21, the nays are 0. SB 349 has received a 2/3 vote, is declared passed and ordered to the Assembly.
Senate Bill 355, introduced by Senators Lang and Hammond, revises provisions relating to financial services. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1 and Section 1.
Are there any amendments?
There are none. Section 18, end of subsection 2, end of bill.
Senator Hammond.
Thank you, Mr. President. Senate Bill 355 revises various provisions concerning financial institutions licensed in this state. The bill authorizes an employee of a financial institution under certain restrictions to engage in the business of lending in this state from a remote location separate from the principal place of business or branch office, if authorized by the licensee in accordance with the certain requirements. In addition, the bill requires a financial institution that owns or licenses computerized data that includes personal information to, after discovery or notification of a breach of security of the data, notify any resident of this state whose personal information was or is reasonably believed to have been acquired by an unauthorized person. The bill sets forth requirements for such notifications, including notifying the Attorney General if the breach of security of the computerized system affects more than 500 residents of this state. In addition, the bill extends existing provisions governing the requirements for a financial institution to report known or suspected exploitation of older or vulnerable persons to include procedures that a financial institution may follow to temporarily delay a requested disbursement from or a transaction involving an account of an older or vulnerable person.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 20, the nays are 1. SB 355 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 359, introduced by Senators Orenshaw and Krasner, revises provisions governing juvenile justice. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 12 into Section 12 into bill.
Senator Orenshaw.
Thank you, President. Senate Bill 359 expands the definition of community service to include a community-based activity that facilitates civic engagement, facilitates or enhances connections between a child and his or her community, provides training in life or job skills, or increases the employability of a child, and is designed to achieve certain identifiable goals. The community service must be performed for and under the supervising authority of certain public entities or a private nonprofit corporation. The bill also revises provisions governing the suspension of a driver's license or delaying the ability to apply for a driver's license. Finally, the bill removes the requirement that the court order the child to pay a fine for a first offense regarding truancy, instead authorizing the juvenile court to order the child to perform an additional 10 hours of community service for a combined total not to exceed 20 hours.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 21, the nays are 0. SB 359 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 370, introduced by Senators Canizaro, et cetera, revises provisions relating to the protection of consumer information. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 35 into subsection 8 into bill.
Senator Canizaro.
Thank you, Mr. President. I rise in support of Senate Bill 370, which seeks to regulate health data privacy pieces. This bill prescribes protections for consumer health data that is maintained and used by certain entities that might produce or provide products or services targeted to consumers in this state. The bill requires those regulated entities to develop and maintain privacy policies and to obtain consent from consumers before collecting or sharing health data. The bill also requires entities to establish methods for consumers to request information about their data and to request for data deletion. The measure provides requirements governing a regulated entity's response to consumers' requests, including timeframes for responding, and that an entity may respond free of charge in most circumstances. Further, the bill prohibits the sale of consumer health data without written authorization and restricts implementing geofencing around healthcare providers. Those regulated entities are required to implement security measures and limit access to consumer health data. In addition, this bill also seeks to establish provisions for the protection of what we might typically call biometric identifiers. Those are things like facial, fingerprint, or iris data, and establishes requirements for the collection, possession, sharing, and sale of that type of data. This puts parameters around persons who possess biometric identifiers and require them to develop, maintain, and comply with written policies setting forth the retention and destruction of those biometric identifiers, and those must be made available to the public. The bill provides that violations of the provisions of this bill are considered deceptive trade practices and provides that provisions concerning consumer health data and biometric identifiers do not apply to data that is collected or disclosed under certain provisions of federal law or regulation or state law. I would urge your support, my colleagues, for Senate Bill 370. This is an effort to help protect what is very sensitive health data that is sometimes shared on apps, and seeks to strike a balance between allowing individuals to use those applications to seek information about their own health, while not also being subject to releasing that out into the world or to be subject to other issues that may occur. I will recognize that this bill is still in the process, I think, of some negotiations, and I remain committed to continuing to work on this bill as it moves through the legislative process. I do think it is establishing some good guidelines for consumer protection around that very sensitive health data, and so I would urge your support of Senate Bill 370.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Does anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 13, the nays are 8. SB 370 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 384, introduced by Senator Daley, establishes certain provisions relating to the award of grants of federal money by a state agency for the development of broadband services and infrastructure. The people of the state of Nevada, represented in Senate Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 4 under subsection 2 under bill.
Senator Daley.
Thank you, Mr. President. Senate Bill 384 revises provisions relating to the development of broadband services and infrastructure. The bill sets forth certain requirements related to the awarding of grants of federal money by state agencies based on certain factors in relative weight. The bill also requires applicants, broadband service providers, and contractors, in order to receive a certain weight in the application process, to certify that will meet certain safety and training requirements, provide job opportunities with high-quality wages to residents of the state of Nevada. The job also requires the payment of a prevailing wage for the construction portion of the work. Thank you.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 13, the nays are 8. SB 384 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 391, introduced by Senator Harris and Assemblyman Watson Bacchus, revises provisions relating to governmental entities. The people of the state of Nevada, represented in Senate Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 4, this act becomes effective upon passage and approval. End of bill.
Senator Harris.
Thank you, Mr. President. Senate Bill 391 prohibits a county, a city, and an unincorporated town from sounding a siren, bell, or alarm for any purpose other than alerting persons to an emergency, testing the siren, bell, or alarm at a reasonable time intervals of not more than once every 6 months, or celebrating or recognizing a legal holiday. This bill further authorizes the Attorney General to bring a civil action to collect a monetary penalty of up to $50,000 from a county, city, or unincorporated town for each violation. Finally, the bill prohibits a county, city, or unincorporated town from making adverse employment action against an employee for reporting such a violation to the Attorney General or law enforcement. The bill is effective upon passage and approval. And I'd like to just note that I understand that this bill is a little broad. It's broader than ideally I would like it to be. However, there is no way to constitutionally draft a law that targets one particular town or city, and nor do I think it's necessarily fair to do so. I, however, am committed to figuring out some way, if it is out there, to allow certain towns who have noble intentions to continue their historic traditions. I have yet to figure out how to do that without giving other towns an avenue to continue to flout this body's intentions. And so I bring forward today a bill that I believe is in fact a bit heavy-handed, but here we are. We took a nice scalpel approach to this issue last session and in fact landed ourselves back here again. And so it is my intention to solve this issue once and for all. And that's what this bill is intended to do. So I invite all folks who are smarter than me to bring their brains to figuring out how to single out a town without singling out a town. But I just don't know if that is quite possible here in this body without violating the constitutional rights of each state and territory. But if we can find a way, I'm down. Thank you, Mr. President.
Remarks from the floor, Senator Titus.
Thank you, Mr. President. And I do rise in opposition to this bill, and I appreciate my colleague's comments about what she indeed is trying to accomplish here. I will admit that in the turn of the century, the horn in the town south of here, Minden-Garnerville, did sound at 5 o'clock, and the intent was to make sure everybody went home. Times have changed, however, and that is no longer the case. There are over dozens of communities in rural Nevada that use the siren now not to send as a curfew message, but really for EMS purposes. And I want to read you what I received from the mayor of Fallon, who's been the mayor literally for decades, Mayor Ken Tedford, who said, "Our whistle does not and has never signified a curfew. Our whistle is not associated with any desire to drive any person away from our community. Rather, it is intended to keep drivers alert and that they are sharing the road with an emergency. It is indeed for public safety purposes." Many of our communities sound that siren, and I know the intent of the bill was changed, that they could practice and send it out every 6 months, but that truly is not enough. So truly, we do have to work on the bill, and I appreciate the offer there, so that, number one, these sirens are not seen as a curfew, but indeed what they're intended to do, which is an EMS alarm, a sound to set your clocks by, but no intent of sending anybody home. Thank you, Mr. President.
Senator Krasner.
Thank you, Mr. President. I stand in support of SB 391. I'm so grateful to the author of this bill for bringing it back. Those of you who do not know, this and a very similar bill was brought in the 2021 session, AB 88. And it specifically stated language about a siren or alarm previously sounding to require persons of a particular race, ethnicity, national origin, or color to leave the county, city, or town. I think those are excellent words to make it crystal clear in the bill, and I'm happy to work with you on it. I sat through this bill hearing, and there were 2 full rooms of people. One room was so full they had to open an overflow room that was also full. Native American Indians, persons of color, they testified one after another that the sirens are offensive to them, that they're offensive to their parents, their grandparents, their great-grandparents, and it's a stinging reminder every single day of what they went through. They testified how that if they weren't home at dark because of the siren, they were beaten, the women were raped, that people would disappear. During the hearing, 2 full rooms of people testifying in opposition. They talked about the psychological impact of hearing the siren every single day. I urge your support. Thank you.
Senator Hansen.
Thank you, Mr. President. I have several small towns in my district who have some type of siren or bell or whistle that has absolutely nothing to do with any racial issue whatsoever. And because this bill is so broad, you're literally punishing several dozen small cities in the state of Nevada because of the misdeeds of one town from at least 75 to 100 years ago. It doesn't make a lot of sense. Now, in conversation with the bill sponsor from District 11, obviously she does want to try to solve the issue, but this idea that you're going to go in and punish every other small town in Nevada because of something that occurred 75 or 100 years ago in Minden-Gardnerville makes no sense. And while I am sympathetic to what may have happened in the past, I think at some point we have to go forward and learn to get along together. And if we're going to constantly bring up past issues, then I think we're never going to be able to come together and have some level of harmony in our communities if we're constantly going to be bringing up these things. One suggestion I may have, it would be very interesting to have, now the tribe involved is the Washoe tribe, it would be very interesting to actually have a vote among the Washoe tribe itself as to whether or not they want this siren removed. If in fact they voted to get rid of it, then they'd have a much stronger case in this building. That's because there's some very aggressive activists that want to try to create a harmony or actually to reopen an old wound and eliminate some racial harmony that's occurred in the last 50 years in those communities, I think is a mistake. Because I grew up in Nevada, grew up with lots of Indian kids, went to school with them. Right now I represent a whole bunch of different Indian colonies and reservations. And I think that if you were to ask the Washoe Indian tribe, and maybe I'm totally wrong, but I think at some point they would want to see these kind of things healed up too. And I would urge this body to vote no, not because we want to somehow harm people and hurt them from psychological things that may have occurred 75 years ago, but because we need to move forward and start creating some level of racial harmony in our communities and not punish communities that had nothing to do with this at all. So hopefully we can work out some kind of resolve. I would love to have an opportunity to actually hear from the entire tribe itself that was impacted by this. But in the meantime, I think we should vote no because we should not be punishing cities that have absolutely nothing to do with the behavior that occurred in the Minden-Gardnerville area that ended at least 75 years ago. Thank you, Mr. President.
Senator Scheibel.
Thank you, Mr. President. I'm proud to rise in support of this bill today. I think that we tried to take the measured approach. We tried to pass the narrowly tailored bill that would only target cities that were truly and clearly bad actors still utilizing these sirens for purposes of antagonizing people of particular races, and that didn't work. So we're back today, and I stand with my colleague from Senate District next to mine, I think it's 11, in trying to rectify this problem because the comparison isn't fair. It isn't fair to compare for a Native American Indian or a black person living in Nevada having to listen to that siren every day versus a white person or another person who was not similarly affected by the sirens having to endure the silence for 24 hours a day. Give me a break. That is not a punishment. Not being able to signal an extremely offensive, racist signal every single day is not a punishment. That should be our norm. We should expect our towns, our cities, our municipalities not to antagonize particular members of their constituency. And the fact that we have to come in here and tell certain towns that that is the law is frankly sad to me. And so I don't think it is fair for anybody to suggest that there are two sides to this issue that have equal weight, that are both just trying to accomplish the same thing, that one side is going to suffer if this bill passes, because one side what? Isn't going to get to hear the siren, isn't going to get to hear the bell every single day. That is not a punishment. That is the smallest possible step that we can take to protect, support, and uplift a section of our community that has been systemically discriminated against, and for whom hearing this siren is incredibly offensive, and for whom the siren signals everything that is wrong with the history of our country and our state. And if what we want to do is to move forward and to talk about the things that we agree on, and to talk about racial unity, and to talk about resolving our differences, then we should do it by, number one, removing the barriers and removing the signals that say to certain members of our state, you don't belong here. Because everybody belongs here in Nevada, and I urge you all to vote in support of this bill.
Senator Harris.
Thank you, Mr. President. I don't anticipate that this is going to change anybody's mind on this vote, and I didn't intend to share this today, but I want folks to understand that although the ordinance was dropped in 1970, this is not history. I received an email on April 8th of this year, 2023, that says in part, "Too bad they abandoned the sirens to make people like you leave town. I hope Nevadans soon realize that your kind should never be in charge of anything in this country." This history is not history. It is incumbent upon us to put these types of things in the history books. And you can pass an ordinance to say that something means something else. But I guarantee you today that there, unfortunately, are Nevadans who wish that that siren still applied to people like me. That means we need to act. That means that maybe we have to give up our 9 o'clock curfew call. Because history is not in the past. This is today. So where do we go from here, folks? This is the choice that we have. As much as we would all like to think that this siren no longer has this meaning, I've got a couple more emails to read you. Thank you, Mr. President.
Any further remarks? Seeing none, the Secretary will open a roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 17, nays are 4. SB 391 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 393, introduced by Senator Seaver-Scansett, revises provisions related to dental insurance. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 13, end of subsection 2, end of bill.
Senator Sears-Gansert.
Thank you, Mr. President. Senate Bill 393 requires dental care insurance providers to report annual losses and premiums collected at the end of each calendar year to the Commissioner of Insurance. Based on the reports, the Commissioner must calculate average loss to premium ratios and identify providers with excessive rates. The Commissioner must also publish an online list of dental care insurance providers and their aggregate average loss to premium ratios. The Commissioner may examine the accounts, records, and transactions of insurers for compliance, and if the Commissioner determines that an insurer is charging excessive rates, the insurer must submit an adjusted rate filing. And the Commissioner may order compensation plans for insured persons who are affected. The effective date of this, the provisions of this bill related to insurers making annual reports to the Commissioner and Commissioner conducting examinations for compliance are effective on January 1st, 2024. Other provisions of the bill are effective on January 1st, 2026. Thank you.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 21, the nays are 0. SB 393 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 394, introduced by Revenue and Economic Development, revises provisions governing abatements and partial abatements of certain taxes. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 7, this act becomes effective on July 1, 2023. End of bill.
Senator Neal.
Thank you, Mr. President. SB 394 prohibits the Governor's Office of Economic Development from approving any tax abatement that exceeds $500,000. So I want to bring up what was the intent of this particular committee bill. So in effect, what this does is make the Office of the Governor's Economic Development Office have to come to the legislature for any abatement that would be over $500K. I think that this measure was brought forward, well, for me, is because I think we've lost sight of the balance of power in how we give away tax abatements in the state. Number one, I think I'd reached my limit on the state watching GoEd give huge tax abatements to Tesla, then Tesla 2, and then the legislature not having any say in how our money is then abated and then given away to a large corporation. I think we need to start making a statement about what we give to billionaires in the state of Nevada. It's interesting how we can give benefits to the rich, but we won't sit down and give that kind of abatement to the poor. We won't sit down and give it a tax abatement in order to build supportive housing, which will take care of our homelessness problem, but we'll give $200 million in abatements, $500 million in abatements to a billionaire so he can get wealthier and not have to pay taxes in the state of Nevada. And so SB 394 was my way of trying to get at the issue, of trying to bring this issue back into the control of the legislature so that we can make a decision about what we would like to decide to abate in taxes. And I think it's appropriate that we start to at least have the conversation and dialogue around what is the balance of power between an agency and the legislature when it comes to the revenue that we need to generate and the revenue that we're expected to give away.
Any remarks from the floor? Senator Severs-Gansert.
Thank you, Mr. President. I rise in opposition to Senate Bill 394. In 2011, we changed the economic development programs within the state of Nevada. It was moved to the office of the governor, and it was tremendously successful. First, Apple came. They've got a data center that is across the highway from Trick. And then we have Tesla, we have Switch, we have all sorts of companies that really have helped to diversify northern Nevada. When you look at the economy in northern Nevada, it's substantially changed from what it was 12, 14 years ago. It's been a huge success. And when companies come here and they're interested in locating in another place, it could be just an office, it could be a plant, it could be the headquarters, they want a quick response. So part of the reason we've been so successful is because the governor's office and their advisory board and so the governor himself, governor's office of economic development, being able to respond to companies, to be able to make sure that they understand when they come here, it's much easier to do business than in a lot of other states. So the abatements are part of it, and some of the abatements are automatic, and I think that's something we need to review. There's some triggers that we absolutely need to review, but the speed to which we can compete with other states is critically important. The success of diversification is extremely important because we want to have a much stronger and sustainable economy. And we know gaming still is the driver in Las Vegas, Clark County is the driver of our economy right now, but we've also seen that when things like COVID happen, it just falls off the cliff, right? We lead when we have economic downturns and we lag on the way back. So right now we do have a robust economy. When you look at Northern Nevada, again, we're diversified. We need to continue to diversify the entire state, and we can do that in part through being responsive to businesses who want to come here and potentially abating taxes for a limited period of time. So again, I agree that we need to look at the abatements that we have, but the speed to the deal is important, and the proof is the success that we've had in Northern Nevada, but also throughout the state. Thank you.
Senator Hansen.
Thanks, Mr. President. I'm sorry, I'm a little confused I thought the bill had a tax in it, and that's why I was against the bill. Having been involved in the 2011 session, the creation of GoEd, the tax abatements for bringing Tesla here, I was fine with that at the time because we were in an economically desperate time, and we actually were trying to prime the economic pump, which it did. I was opposed to the creation of our current Governor's Office of Economic Development, the way it was set up, the amount of money that they were able to use, and their ability to, as I recall, it was up to like $10 million worth of abatements without any oversight by the legislature. Now, I am concerned 500,000 may be too low, but I absolutely agree with my senator who just spoke from Las Vegas. I think that the whole idea of allowing a separate executive branch agency to make incredible deals with some of these people who frankly don't need it to come here in the first place, the real problem with the whole abatement idea is somebody has to make up the difference, okay? So while we do bring in a big company, somebody has to pay the tax revenues in the meantime that these guys are getting abatements for. Yes, in the long run, it's probably a very good thing. But if that's true, then it would be reasonable for the legislature to have some level of oversight. The idea that we have to do these decisions like immediately or else they're going to go to Texas or somewhere, in some cases that may be true, but in times like now especially, when we actually have a labor shortage in the state, and we have an abundance of businesses that are trying to come to Nevada to escape primarily from places like California, I don't know if we have to have those kind of abatements. And so I'm going to change. I was going to be a no on this because I thought it was a tax increase. I'm going to support this because I think this is something that we, as a legislative body, do need to once again review. And so I agree with my colleague that those original ideas that we had in severe economic downturns like we were experiencing back in the 2011 session, it's night and day difference compared to what we have financially right now. We have so much money, we're spending money like there's no tomorrow. At the time, we were literally cutting programs right and left, and we were desperate to bring any businesses into the state. And Tesla proved to be, it was a gamble when we rolled the dice and let those abatements and brought in Elon Musk and the whole giant factory. But since that time, I've been very nervous about this constant expansion of abatement programs for giant companies that really, frankly, don't need the abatements. So I'm going to actually vote in favor of this bill. So thank you, Mr. President.
Any further remarks from the floor? Senator Stone.
Thank you, Mr. President. Good evening, colleagues. I migrated here from a state that has done everything they possibly can to push businesses out of the state. Sherwin-Williams Paints, Tesla, companies from Silicon Valley. These companies are going to go someplace, and I see Nevada kind of at its infancy with 3.2 million people versus 40 million in the state to the east of us, where we really are at the foundation of our economic base. And I think you'll all agree that we need to diversify our economic base so that we can sustain ourselves during downturns in the economy. I believe that we should be giving the governor the authority to use incentives that have a long-term benefit to Nevadans, to provide new jobs, to provide new tax revenues, and diversify our economic base so that we can survive another pandemic or a downturn in the economy. They say that we're going to have a horrific recession sometime in 2023-24. We want to be prepared for that. But we are competing with other states that operate a lot faster than we do. And I'll give you Arizona as an example. I work for the United States Department of Labor. I work with Governor Ducey, and I saw how fast they were to make a deal to bring high-tech to Arizona. I want those high-tech, high-dollar jobs coming here to Nevada. And you're absolutely right. These are billion-dollar companies, but they're savvy billion-dollar companies that are going to look for the best deal that they possibly can get. Because we're a no-income tax state, we have another benefit that other states don't have. We have land, a lot of it's federally owned, that hopefully will be released so we can further our expansion, not only in the northern part of the state, but in the southern part of the state. But if we don't diversify our economic base, we're going to be sustaining issues from downturns in the economy. Yes, these are incentives, but there has to be a return on investment, and I'll guarantee you that the governor and the executive branch is looking to make sure that the beneficiaries of these deals is not the companies that we're courting here, but the citizens of the state of Nevada. I urge a no vote on this.
Senator Hansen.
Thank you. I agree with my colleague, what he just said, the incentive program. I think we need to remember that 70% of the employment in the state of Nevada are to small businesses, okay? And when you give incentives to these giant companies that come here, the small businesses have to pick up the economic difference. They're the ones that pay additional taxes. And we need to remember that we need to look out for our small business community every bit as much as we do these giant corporations that are going to come here. Yes, it's nice to have those big ones, but we seem to forget that it's actually the small ones that are the drivers economically in this state, and it's the small ones that aren't getting any special abatements. It's only the big ones that are getting these special abatements, and consequently the tax burden falls disproportionately on the businesses that are already here and already provide the bulk of the employment for the citizens of the state of Nevada. Thank you, Mr. President.
Senator Neal.
Thank you, Mr. President. I think I'm tired. So I'm going to say this. I strongly believe in economic diversification. I have carried business legislation in this building since 2011. which has been focused on small business. I thoroughly believe that we need to continue to diversify the state, but I also believe that when it comes to legislative power, the balance between the executive and the legislature, we still have the power financially in order to decide how to raise revenue or whether or not to spend it. And I think the power to abate should come back to the legislature as well. I think, and I understand and I respect my colleague that has come here from the state that is large and has potentially pushed their businesses out. I never want to be like California. And so at the end of the day, I think that we need to have the conversation, whether or not it's through this vehicle, but I think we need to have the conversation about what is the appropriate balance of power that needs to happen in the state of Nevada. We need to talk about how do we diversify, bring in mid-sized to small businesses and allow them to grow within the state of Nevada. Because what we're doing, we're helping billionaires to basically sit and profit off of the state of Nevada without having to give anything back. Their abatements go on for 10 and 20 years. The prior abatement that we had before we changed it under a colleague that is now left to go to the AG's office, we were allowing them to not only come here, but then expand their abatement through their subsidiary. So the initial 10 million could grow into 20 million and 30 million and 40 million because we had a loophole in the law. And so it's time to have a conversation about what's appropriate abatements for the state. What's the measure that we need to move forward in our diversification, and who would we like to come into the state? When we think about the vision for our state, we need to think about what do we want to look like 50 years from now? Would we like to have these huge corporations that are saying, you know what, I also don't want to pay any more taxes. I don't want to pay the ones that you gave me, the abatement that you gave me when it's released, and then all of a sudden we're 20 years down the road looking at the fact that we can't pay for schools, we can't pay for health care, we can't pay for homelessness. We're sitting in this session, this session where everybody is saying, oh, we have this $2 billion, but yet in 2021, we were cutting kids. In 2019, we didn't have any money. In 2017, we didn't have any money. In 2015, we didn't have any money. In 2013, we didn't have any money. In 2011, we didn't have any money. And we were embarking on diversification, but diversification does not mean giving away your tax base.
Senator Stone.
Thank you, Mr. Chair. My concluding remarks, I don't get an opportunity to banter with my colleague from Senate District 14, so I want to take that opportunity to debate him. You know, a lot of these jobs that are being courted to Nevada are manufacturing jobs. Tesla's a manufacturing job. They're manufacturing the batteries. They're going to manufacture electrified trucks. We have chip makers in southern Nevada that have come there to manufacture chips. And for those of you that study economics, you'll know that there is a multiplier effect of about 4 to 5 times the number of jobs that are being created, which includes small businesses. So the beneficiary is going to be entrepreneurs that want to come to Nevada to open businesses to support those large employers, those large manufacturing employers, and the beneficiary also is the people that are getting these jobs that may not have a job here today. So you have to look, I think, in the long term. I guess in 2026, 2027, 2028, when maybe some of these abatements may wind down, there'll be revenue coming into the state that we can pay for the programs that my colleague so passionately says that we need. And we do need them, absolutely. But we need to plant some financial seeds if we want to have a diversified economic base. And I believe that providing the governor with the incentives to court these businesses here is going to accomplish that. So with that, I urge again a no vote.
Senator Severs-Gansert.
Thank you, Mr. President. I know we're beating a dead horse, but I like data. And when the Governor's Office of Economic Development came into our Revenue Committee, they talked about the return on investment. I just want to make it clear. Return on investment for what we abated, which was a partial abatement for Tesla, was 5 to 1. And the current deal, they invested $3 billion the first time, and then they're investing another $3.5 billion. And as was mentioned by one of my colleagues, when they come here, there's all sorts of other businesses that come here. And with that, we've got some growth in northern Nevada, and we've all experienced that in our neighborhoods up here in northern Nevada, which drives sales tax, drives property tax. The businesses drive modified business tax. So according to the Governor's Office of Economic Development, for the last abatement that they did related to Tesla, which was a lesser, much lesser deal, the state would net more than $766 million in new tax revenue over the next 20 years. Quote, that's 115 to 1 return on investment, according to GOED Deputy Director Bob Potts. So again, it's not about just the building where the company may be, where they reside, and just those employees. It's about the growth of the entire economy and the diversification of the economy. So the first return on investment was 5 to 1, and now they're expecting, huge gains on that. And again, it helps small businesses, it helps large businesses, and it's about the bigger picture, not just the building and where that's located. Thank you, Mr. President.
Are there any further remarks? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 14, nays are 7. SB 394 has received the constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 404, introduced by Legislative Operations and Elections, makes various changes relating to elections. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 71, end of subsection 2, end of bill.
Senator Orenshaw.
Thank you, President. Senate Bill 404 sets forth what constitutes satisfactory identification for purposes of a voter challenge based on an allegation of residency, of not having residency in that precinct. The bill further provides that the provisions of existing law relating to voter challenges do not authorize a person to challenge the ability of a registered voter to vote by mail ballot. Finally, the bill requires the counting of the returns for early voting to begin no later than the first day of early voting.
Are there remarks from the floor? Senator Severs-Ganser.
Thank you, Mr. President. I rise in opposition to this bill for a couple of reasons. The proof of where you live is a very low bar. It's like a utility bill or a bank statement. And then, as was just mentioned, the date to start counting ballots is the first day of early voting, right? So right now, we don't count ballots until the election is closed. The first day of early voting is weeks before the close of ballots, and I think that we need to be careful with our elections, and therefore I do not support the bill. Thank you.
Senator Orenshaw.
Thank you very much, Mr. President. While Senate Bill 404 does allow for something like a utility bill to be something that can counter a challenge to residency, if there's a challenge as to identity, that still requires photo identification. And the language in the bill regarding the counting in Section 8, on or after the first day of early voting, the county clerk may order the appropriate board to begin the count. But in any case, the count of the returns for early voting must begin not later than 8 a.m. on Election Day. This would still all be private. No information would be released prior to Election Day. And again, that discretion is given to the county clerk as to whether they want to start the count on the first day of early voting or after, but they must start on Election Day.
Any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 13, nays are 8. SB 404 has received the constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 406, introduced by Legislative Operations and Elections, revises the provisions relating to elections. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 6, this act becomes effective upon passage and approval. End of bill.
Senator Orenshaw.
Thank you, President. Senate Bill 406 makes it unlawful for a person to use, threaten, or attempt to use any force, intimidation, coercion, violence, restraint, or undue influence to interfere with the performance of the duties of an elections official. The bill also makes it unlawful to retaliate against an elections official for performing such duties and to disseminate certain information about an elections official without consent. All of these crimes would be punishable under this bill as a Category E felony. Lastly, the bill authorizes a person to distribute certain items to persons waiting in line at a polling place to vote or register to vote. And I just would like to let the body know that during our hearings, we heard testimony about many clerks, registrars who had decided to leave and stop performing those duties due to threats, due to fear that they had for performing their duties. So I would urge the body to support this legislation.
Are there remarks from the floor? Senator Severs-Ganzert.
Thank you, Mr. President. I rise in support of SB 406. We listened to quite a bit of testimony, and my colleague from Senate Bill 21 pointed out that we had a number of clerks quit because of their harassment, the stalking, the threats that were made to them, which we just cannot tolerate. I think the number was 10 out of 17 clerks quit after the last election, or some quit before. I know in Washoe County we had one that went on leave because of that. So I think we need to send a strong message that we have fair and secure elections and that we should not be harassing our election officials. Thank you.
Are there any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 21, the nays are 0. SB 406 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 407, introduced by Senator Orenshaw, revises provisions relating to personal financial administration. The people of the state of Nevada, represented in Senate Assembly, to enact as follows, Section 1 and Section 1.
Are there any amendments?
There are none. Section 19, this act becomes effective on July 1, 2023. End of bill.
Senator Orenshaw.
Thank you, Mr. President. Senate Bill 407 revises various provisions related to the property of a decedent, including but not limited to court jurisdiction over the estate of a deceased person, the vesting of a homestead of a deceased spouse, how a court is authorized to assign an estate with a value of $100,000 or less, when publication of the sale of real property may be waived, when the requirement to conduct an appraisal of certain property may be waived, the means by which certain notices must be given, the means by which a settlor of a trust may determine whether the settlor or trustee is incapacitated, clarifying the confidentiality of certain pleadings and filings, the fiduciary powers of a protector of a trust, when court jurisdiction over a trust is proper, and clarifying what must be contained in a notice declaring that a revocable trust has become irrevocable. And just want to let the body know, this bill is the product of 18 months of work through the State Bar Trust and Estate section. It was vetted by the State Bar Board of Governors, and it's been thoroughly looked at. I would urge its support. I believe it benefits our constituents with the trust and estates issues that we'll all face.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Senator Stone. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 21, the nays are 0. SB 407 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 415, introduced by Judiciary, revises provisions relating to juvenile probation. The people of the state of Nevada, represented in Senate Assembly, to enact as follows, Section 1 under Section 1.
Are there any amendments?
There are none. Section 2 under subsection 2 under bill.
Senator Scheibel.
Thank you, Mr. President. Senate Bill 415 revises provisions under which a juvenile court may place a child on probation and, with certain exceptions, limits juvenile probation to 18 months. A validated risk assessment and mental health screening must be used to guide terms of juvenile probation. A juvenile court may extend probation up to 36 months under certain conditions and for a longer period upon the agreement of interested parties. Notice of hearings regarding the extension of probation must be given to the child's attorney, probation officer, and parent or guardian. The court must allow the parties to present evidence and testimony and must consider reports from the probation officer and Department of Juvenile Justice Services, as well as the individualized case plan for the child. The juvenile court retains jurisdiction to oversee the payment of fines or restitution.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 21, nays 0. SB 415 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 417, introduced by Judiciary, revises provisions governing common interest communities. The people of the state of Nevada, represented in Senate Assembly, to enact as follows, Section 1 under Section 1.
Are there any amendments?
There are none. Section 5 under subsection 5 under bill.
Senator Scheibel.
Thank you, Mr. President. Senate Bill 417 prohibits a unit owner, tenant, guest, or an invitee of a unit owner and a homeowner association from taking or encouraging another person to take retaliatory action against an executive board, a board member, or an employee for certain conduct. It also makes it a misdemeanor for certain persons within a common interest community to bully another person within the same common interest community. The bill removes information relating to personnel from the list of records that a board must make available to the public and provides that a unit owner must pay the actual cost incurred by an association Association to provide records for review. Finally, the bill authorizes the Commission on Common Interest Communities and Condominium Hotels to impose sanctions disqualifying a person from serving as a member of the Executive Board on any person who files a vexatious, misleading, retaliatory, frivolous, false, or fraudulent affidavit with the Real Estate Division.
Are there any remarks from the floor? Senator Stone.
Thank you, Mr. President. I applaud our chair for bringing this forward. I support SB 417. Probably one of the most thankless jobs is probably being a member of an HOA. The abuse that sometimes that they take. My concern of the bill has been the definition of retaliation and making sure that one's constitutional First Amendment rights are still protected. I've been working with some of the proponents of the bill that have promised some amendments that will come in the Assembly. They're going to address the social media aspects and making sure that if you make a threat to recall a board, that's not considered to be retaliatory. They've been very cooperative. I look forward to seeing those amendments in the Assembly, but I'm going to be voting for this today and urge the Senate to vote yes today. Thank you.
Any further remarks? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 20, the nays are 1. SB 417 has received a constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 422, introduced by Growth and Infrastructure, revises provisions relating to public safety. The people of the state of Nevada, represented in the Senate Assembly, do enact as follows, Section 1, end of Section 1.
Are there any amendments?
There are none. Section 11, end of subsection 2, end of bill.
Senator Harris.
Thank you, Mr. President. Senate Bill 422 establishes requirements governing the operation of a personal delivery device operated autonomously, semi-autonomously, or remotely, and is intended to transport cargo on pedestrian walkways and in designated areas, including Nevada System of Higher Education campuses, offices, and associated facilities. In addition, the bill authorizes a city or county to enact ordinances which regulate the time, place, and manner of operation of mobile carrying devices, including the design of the device, and require a business license or fee. Finally, a city council governing body may enact ordinances which prohibit the transportation of alcohol and cannabis. This bill is effective upon passage and approval for the purpose of adopting regulations and performing preparatory administrative tasks, and on January 1, 2024 for all other purposes. You may have seen these small little robots, we're calling them pizza bots affectionately, around on UNLV Day. These delivery devices are bringing food safely to a lot of our kids on campuses. We want to make sure that we can have these robots deliver across the street or just across or adjacent to the campus where a lot of campus students are, so that they don't have to go through another delivery service and spend quite a bit more to get their food delivered to them. Counties are in support, UNLV's in support, Starship, who makes these cute little things, as well as Grubhub, who assists in these deliveries as well. It's a good bill. I urge your support. Thank you.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 21, the nays are 0. SB 422 has received the constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 427, introduced by Government Affairs, revises provisions relating to occupational safety and health. The people of the state of Nevada, represented in the Senate Assembly, do enact as follows, Section 1, end of Section 1.
Are there any amendments?
There are none. Section 3, end of subsection 2, end of bill.
Senator Flores.
Thank you, Mr. President. Senate Bill 427 requires an existing written safety program established by certain employers to include a program to mitigate heat illness on days that the temperature is expected to be 105 degrees Fahrenheit or greater, regardless of whether the employer works outdoors or indoor without climate control. A program to train employees who may be affected by issues related to heat illness, a program to mitigate exposure to poor air quality when the air reaches an Environmental Protection Agency air quality index value of 201 or greater, and a program to train employees who may be exposed to poor air quality on the hazards of working without personal protection equipment. The bill requires programs and trainings to be provided in a language and format understandable to each employee. Finally, the bill exempts certain emergency services personnel from the requirement of this bill. Members, I urge your support. I will say that the bill's been amended significantly from its original drafting, and that we have had ongoing working groups composed mostly of folk who have had some concerns or issues with the bill. We will continue to work along with those folk who have issues. But I want to remind folk, this bill triggers when it's 105 degrees. We want to create a minimum standard that when it's 105 degrees in a working condition, you provide water. As I look around this room, every single one of you has water. It's not 105 degrees. That's because most employers, in fact, every single employer that I spoke to, provides water. We are saying that when it's 105 degrees, you should provide water. And if you're curious what that translates to, in Las Vegas in 2022, it was 105 degrees outdoors 38 times. That's it. In Reno, once. The other thing that the bill says is that when the air quality index is at 201 or greater, that you have some type of protective gear provided to your employees. If you want to know what that translates to, in Clark, that was 3 times in 2022. In Washoe, it was twice in 2022. These are minimum standards. I don't know a single employer in the state of Nevada that would send somebody to work in hot working conditions and not provide water. I don't know a single employer in the state of Nevada that would make some folk go work in poor air quality and not provide some mask. It is bare minimum standards that we are asking for. And I know that lobbyists have come around and there's concerns, and I appreciate that. But I'm telling you that we've been working with them, and we're going to continue working with them. What we won't allow, however, is for anybody to walk into my office, as it happened, while we're trying to work in good faith, and somebody wave their finger and threaten that we either take their negotiation or otherwise they're going to have some power over this body and circumvent the good faith process that we have. And I say that to you because I needed to put it on the record and I needed it to be abundantly clear. But to everybody else working in good faith, my door is open and I will continue to work with them.
Are there remarks from the floor? Senator Hansen.
Thanks, Mr. President. I do appreciate the sponsor, and he has worked aggressively. You know, I've been a contractor in Nevada for 37 years now. I'd say the majority of that has been outdoors. And all of the things in this bill, frankly, we've been doing for 37 years at least that I know of. There's no, like he pointed out, there are no employers that wouldn't give people water in the first place. Secondly, in the construction industry, my guys don't ask for water. They go and get whatever they need, you know. So the idea that there's all these people that are being denied water on hot days, I just have a hard time believing that's the case. I think the problem with the bill really is it's getting down to a micromanagement level. As a construction worker, we had every week a safety meeting. We would have a different topic, literally 52 weeks out of the year. Heat stroke, things like that were always covered. Of course, in the north, a lot of times it's not heat, but it's intense cold. Believe me, I've worked outside on days that are incredibly miserable, so that also is a factor, more so in the north, obviously, than the south. But I'm certainly not against the idea of safety, but you do reach a point where it is micromanaging, it's duplication of efforts. All the things that are in this bill are already required to one degree or another by OSHA and by other federal standards, and it's just like adding on more layers of regulation for items that are already provided to workers and to contractors in the state of Nevada now. So simply on the basis of redundancy, I would just urge my colleagues to vote no. This is already covered in law. Thank you, Mr. President.
Senator Donate.
Thank you, Mr. President. I rise in support to this bill, and I want to thank my colleague from Senate District 2 for bringing this issue forward. I'm not sure if I've ever had the chance to speak about this publicly, but many of my family members work outdoors. My first job was on the top of the stratosphere on the rides, working outdoors. And to this day, my siblings have 2 brothers that are both landscapers. Within the past year, during the summertime, my siblings have passed out. Many of my family members, my cousins, my uncles, are landscapers as well, and they have been hospitalized due to heat-borne illness. This is an issue that personally affects me and personally affects many of the workers that are in my community. We know that when we provide these workers, our frontline workers that work outdoors, the services that they need, the equipment, and in this particular case, services like access to water and recognizing the training that you need for when you are experiencing certain symptoms. These are quality measures that can help protect workers in the front. There's one portion of this bill that I believe we have to have a conversation at some point, which is what happens in the instance when workers aren't able to fulfill their responsibilities due to the outlying quality factors that impact their work. We have instances where, because of the changing climate, either it's becoming incredibly burdensome because of the heat outside of our environment, or instances like air quality measures due to wildfires. We have an obligation to protect workers that might not be able to complete their work, and I believe that this bill gets us a step further to protecting the workers that serve our state, and I encourage my colleagues to please vote in support of this bill. Thank you.
Senator Buck.
Thank you, Mr. President. OSHA has the authority to regulate heat illness through the general duty clause of the existing law. Placing the requirements in statute is unnecessary, and the bill is too broad and doesn't take into consideration all the various industry differences. How do you monitor drivers for heat illnesses who are remote? The bill would still require shade at night. What does cool water mean? Common sense for a few bad actors should not be legislated. I caution my colleagues as we should not enact a law that makes it easy to utilize the ambiguity within it as a weapon against business.
Senator Flores.
Thank you, Mr. President. I just wanted to clarify that, and I do appreciate the comments of my colleague. Good actors are obviously already doing this. Unfortunately, there are folk who are not working for good actors, and I agree that these are businesses in the minority, but we have a responsibility to ensure that we create some minimal safeguards in the state to ensure that they have some protections for them. And yes, I actually somewhat agree with my colleague's previous statement that we don't want to create one rule that fits for all industries. That's why it's broadly written so that each industry can write its own specific rules. That's the way the bill is written now, that each industry will create a plan that fits its specific business plan. And that's intentional because we don't want to ensure that everybody has to play one single rule when some folk are driving trucks while some other folk may be at a ranch while other folk may be in a remote area. So the bill is very broad so that we allow for that flexibility. Thank you, Mr. President.
Are there any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 13, the nays are 8. SB 427 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 429.
Mr. President, can
Yes,
we get
Senator.
a brief recess?
We are in brief recess. The Senate is back in order. We are on order of business 13.
Senate Bill 429, introduced by Government Affairs, requires certain new or expanding businesses to provide certain family and medical leave to employees in order to qualify for a partial abatement of certain taxes. The people of the state of Nevada, represented in the Senate Assembly, do enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. End of bill.
Senator Flores.
Thank you, Mr. President. Senate Bill 429 establishes that certain abatements of taxes for new and expanding businesses in Nevada can only be granted by the Governor's Office of Economic Development for businesses with 50 or more full-time employees if the applying business provides at least 12 weeks of family medical leave at the rate of at least 55% of the regular wage of an employee who has been employed by the business for at least 1 year.
Are there any remarks from the floor? Senator Severs-Gansert.
Thank you, Mr. President. I rise in support of Senate Bill 429. We had the hearing in committee, and we heard testimony about how important it is actually to professional working women to have FMLA, and also if you are caretakers for other members of your family. And I'm not sure if this was mentioned or not, but this would only be a couple things that was mentioned. One was mentioned. This is only for companies that receive abatement, so it's not across the state. It's just only companies that are abated, and if they are able to provide the FMLA, they also get a federal tax credit. So there's even a greater incentive for them to add these programs to their benefits. Thank you.
Are there any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 17, the nays are 4. SB 429 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 434, introduced by Senator Neal, revises provisions related to retirement. The people of the state of Nevada, represented in the Senate Assembly, do enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 4, this act becomes effective upon passage and approval. End of bill.
Senator Neal.
Thank you, Mr. President. SB 434 makes substitute teachers eligible for membership in public employees retirement system. The bill also provides a system members the option of reduced service retirement allowance with a benefit paid to a beneficiary for 6 months after a retiree's death. The measure further requires a court in granting a divorce to provide an explanation or ensure that an explanation has been provided to the parties relating to a qualified domestic relations order. Finally, with respect to the disposition of a pension or retirement benefit, it replaces the time rule with the frozen benefit rule. Under the frozen benefit rule, the community interest in certain retirement benefits is frozen at the salary base in the years of service of the party participating in the retirement system on the date in which the decree of legal separation or divorce is entered.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 19, the nays are 2. SB 434 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 436, introduced by Commerce and Labor, revises provisions relating to service contracts. The people of the state of Nevada, represented in the Senate Assembly, do enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 3, end of Section 3, end of bill.
Senator Spearman.
Thank you, Mr. President. Senate Bill 436 requires the Commissioner of Insurance to submit a report to the Joint Interim Standing Committee on Commerce and Labor containing certain information concerning the service contract industry in Nevada on or before December 31st, 2023, and on or before December 31st of each year thereafter. The bill is effective on October 1, 2023.
Are there any remarks on the floor? Senator Stone.
Thank you, Mr. Chair. I just want to applaud the author for bringing this forward. There has to be some accountability with these home warranty services, especially in the South when their HVACs go down and people are without air conditioning for weeks, 2 weeks, 3 weeks at a time. I applaud the author and I urge an aye vote on this. Thank you.
Any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 21, the nays are 0. SB 436 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 437, introduced by Commerce and Labor, revises provisions governing accountants. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 under Section 1.
Are there any amendments?
There are none. Section 22, this act becomes effective on July 1, 2023. End of bill.
Senator Buck.
Thank you, Mr. President. Senate Bill 437 extends the authority of the Nevada State Board of Accountancy to grant certain practice privileges to a certified public accountant firm organized as a corporation, limited liability company, partnership, or sole proprietorship that holds a valid registration in good standing from another state. These entities do not have to obtain a certificate or permit form or register with the board, but they must consent to certain conditions and maintain an office in Nevada unless organized as a sole proprietorship. The bill also exempts from the registration requirement certain entities whose sole business is preparing tax returns and related schedules. In addition, the bill revises certain provisions governing the requirements for a person to qualify for a certificate or of certified public account and authorizes rather than requires the board to charge a fee for an associated examination. The effective date of this bill is July 1st of 2023.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 21, the nays are 0. SB 437 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 39, introduced by Judiciary, provides that certain records received, obtained, and compiled by the Board of Indigent Defense Services and the Department of Indigent Defense Services and the Department are confidential under certain circumstances. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 under Section 1.
Are there any amendments?
I have amendment number 533, proposed by Senator Scheibel.
Senator Scheibel.
Thank you, Mr. President. I move to dispense with the reading of Amendment 533.
If there are no objections, so ordered. Senator Scheibel.
I move to adopt Amendment 533 to Senate Bill 39.
You've heard the motion. Senator Scheibel.
Amendment 533 adds language clarifying that the bill's provisions apply to both the Board of Indigent Defense Services and the Department of Indigent Defense Services. It further clarifies that certain communications or record sharing between the board and the department and certain other entities is permitted in relation to an investigation of a complaint against an attorney pertaining to the attorney's representation of an indigent client.
Are there any remarks on the amendment? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. Bill number 39 is ready for final action.
Senate Bill 39, introduced by Judiciary, provides that certain records received, obtained, and compiled by the Board of Indigent Defense Services and the Department of Indigent Defense Services and the Department are confidential under certain circumstances. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1 and to Section 1. There are no further amendments. Section 4. This act becomes effective upon passage and approval. End of bill.
Senator Wynn.
Thank you, Mr. President. Senate Bill 39 provides that with certain exceptions, all records received by the Board of Indigent Defense Services and the Department of Indigent Defense Services that are protected by attorney-client privilege are confidential. Similarly, all records obtained and compiled on or during or after the investigation arising from the complaint related to the attorney or conduct are confidential except when releasing such records is necessary for the performance of oversight functions by the board or the department. The bill also sets forth circumstances under which the department may share information with licensing boards or other entities that are investigating a complaint against an attorney pertaining to the representation of an indigent client.
Are there any remarks from the floor? Senator Severs-Gansert.
Thank you, Mr. President. I rise in support of Senate Bill 39. I appreciate the amendment, which cleared up language so that the records related to compensation or expenses made by attorneys is no longer sealed, and also any complaint against an attorney pertaining to the representation of an indigent client will also not be sealed. So I appreciate the amendment. Thank you.
Are there any further remarks? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 21, the nays 0. SB 39 is amended, has received the majority, is declared passed and ordered to the general file. I'm sorry, order to the Assembly, okay. Yeah, order to the Assembly.
Senate Bill 133, introduced by Senators Daley, et cetera, and Assemblyman Yeager, et cetera, revises provisions relating to presidential electors. The people of the state of Nevada, represented in Senate Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 4, this act becomes effective upon passage and approval. End of bill.
Senator Daley.
Thank you, Mr. President. Senate Bill 133 prohibits a person from creating or serving in a false slate of presidential electors or conspiring to commit such acts. A person who violates these provisions is guilty of a Category B felony and may be subject to a fine and liable for the costs of investigation and prosecution. The bill authorizes a person who believes that such an offense has occurred to notify the Secretary of State, who then must investigate or refer the alleged violation to the Attorney General for investigation and prosecution. Finally, the bill prohibits a person convicted of such offense from being elected or appointed to public office.
Are there any remarks from the floor? Senator Severs-Gansert.
Thank you, Mr. President. I rise in opposition to Senate Bill 133. It has very broad language and it extends subpoena powers to the Secretary of State. It has a Category B felony, which is a very high level for folks who may be pretending to do something. And I also think our elections have been safe and secure, and that this bill is is an overreach as far as the response. But especially with the subpoena power, right now the Secretary of State does not have subpoena power, and if you need to investigate, they can investigate. But then the Attorney General has that type of authority, and that's where this belongs. Thank you.
Senator Scheibel.
Thank you, Mr. President. I'll also be voting no on this measure today, but I just want to make a very clear statement about the reason for my no vote today is that I absolutely believe that we should hold people accountable who engage in this kind of fraudulent and frankly treasonous behavior. However, the Nevada revised statutes allows judges discretion to grant probation to people in all kinds of offenses, including battery with a deadly weapon, shooting at people, stealing from them, abusing animals, all kinds of, almost every single offense has the option of probation from a judge, including those resulting in people's death. And so I just don't think that it is appropriate to signal that this is worse than those crimes by by tying a judge's hands and saying that they can't give a person convicted under the statute probation, and that's why I'll be a no today.
Any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 11, the nays 10. SB 133 has received a constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 194, introduced by Senators Orenshaw, et cetera, revises provisions relating to step therapy protocols to people of the state of Nevada, represented in Senate Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
I have amendment number 530, proposed by Senator Orenshaw.
Senator Orenshaw.
Thank you, Mr. President. I move to dispense with the reading of Amendment 530 to Senate Bill 194.
If there are no objections, so ordered. Senator Orenshaw.
Thank you, President. I move that the Senate adopt Amendment 530 to Senate Bill 194.
You've heard the motion. Senator Orenshaw.
Amendment 530 to Senate Bill 194 explicitly excludes any policy of group health insurance purchased or provided for employees of a local government agency from the requirement in the bill to provide an exemption from a step therapy protocol.
Are there any remarks from the floor on the amendment? Seeing none, all those in favor signify by saying aye. Aye. Opposed, nay. Motion carries. SB 194 is ready for final action.
Senate Bill 194, introduced by Senators Orenshaw, et cetera, revises provisions relating to step therapy protocols to people of the state of Nevada, represented in Senate Assembly, to enact as follows, Section 1, end of Section 1. There are no further amendments. Section 13, end of subsection 2, end of bill.
Senator Orenshaw.
Thank you, Mr. President. Senate Bill 194 requires certain private health insurers to establish a process for a covered person or attending practitioner of that covered person to request an exemption from that insurance company's step therapy protocol, as well as establish a process to appeal a decision made by the insurer concerning a request for an exemption to that step therapy protocol. The bill sets forth the circumstances under which the insurer would be required to grant the exemption and the timeframes within which a health insurer must respond to a step therapy exemption or appeal request before the request is deemed to have been granted. If the insurer grants the exemption or the exemption is deemed granted, the bill requires health insurers to immediately authorize coverage for the requested prescription drug chosen by the attending practitioner for the insured. A health insurance policy issued or renewed on or after January 1 to 2024 has the legal effect of including the required coverage, and any provisions of the policy that are in conflict are void.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 21, the zeros, the nays are 0. SB 194 as amended has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 243, introduced by Senators Wynn, et cetera, and Assemblywoman Torres, et cetera, revises provisions relating to catalytic converters. The people of the state of Nevada, represented in Senate Assembly, to enact as follows, Section 1 into Section 1.
Is there an amendment?
I have amendment number 502, proposed by Senator Scheibel.
Senator Scheibel.
Thank you, Mr. President. I move to dispense with the reading of Amendment 502.
If there are no objections, so ordered. Senator Scheibel.
I move to adopt Amendment 502 to Senate Bill 243.
You've heard the motion. Senator Scheibel.
This amendment revises the penalty for certain violations involving the theft or sale of 10 or more catalytic converters from a Category B felony to a Category C felony.
Are there any remarks on the amendment? All those in favor signify by saying aye. Opposed, nay. Motion carries. SB 243 is ready for final action.
Senate Bill 243, introduced by Senators Wynn, et cetera, and Assemblywoman Torres, et cetera, revises provisions relating to catalytic converters. The people of the state of Nevada, represented in Senate Assembly, to enact as follows, Section 1 into Section 1. There are no further amendments to this bill. Section 15 into Section 15, end of bill.
Senator Wynn.
Thank you, Mr. President. Senate Bill 243 sets forth provisions defining the offenses for theft or possession of a catalytic converter and provides graduated felony penalties for those offenses depending on the number of catalytic converters involved. A scrap metal processor who knowingly purchases, receives, or sells a used catalytic converter that is not properly obtained or documented is subject to similar penalties as set forth in regards to theft or possession of a catalytic converter.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The ayes are 20. The nays are 1. SB 243 as amended has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 251, introduced by Senator Flores, revises provisions relating to employees of school districts. The people of the state of Nevada, represented in Senate Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 3, this act becomes effective on July 1, 2023, end of bill.
Senator Flores.
Thank you, Mr. President. Senate Bill 251 adds policies for the transfer and reassignment of school district employees who are not teachers to the mandatory scope of collective bargaining for a local government employer. The policies must include the transfer and reassignment of employees of a large school district which has more than 100,000 pupils enrolled in its public schools during or in response to a reduction in workforce or in a surplus situation. Additionally, the bill provides that a large school district remains responsible for negotiating the policies for the transfer and reassignment of the school district employees, including policies that provide placement rights to employees affected by a surplus situation during or in response to a reduction in workforce.
Are there remarks from the floor? Seeing none, Senator Buck.
Thank you, Mr. President. This is another rinse and repeat forced placement bill where inevitably you place staff at a school and then you hold the principal accountable for the results of the school on the Nevada School Performance Framework. So when you place a person at a school and the community, the SOTs don't have a say over who is placed at the school, nor the principal has any say in that placement. I'll use CCSD as an example. Currently, CCSD has 1,283 openings for teachers. So anyone can apply. And supposedly there's 5 to 7 teachers out there that cannot get a job, even though they've been on multiple interviews. So I ask you, what could potentially be wrong? I think that the unions need to try and coach these people, because obviously there is a problem if you can't find a job out of 1,283 openings. So put yourself in the principal's shoes. Would you rather pick who works in your school or have someone randomly or arbitrarily placed there to teach children? As a principal, you are responsible for the Nevada School Performance Ratings and the results of student achievement. Now imagine having zero control over hiring the very people who impact student success in your school each and every day. Can you imagine running a business with no autonomy over staffing? I could not, as an empowerment principal. We were lucky enough to have autonomy over staffing, scheduling, curriculum, budget, and time. It made all the difference in moving the needle on student achievement. The autonomy of staffing is so important to moving the needle for student achievement. On another note, the more regulations, mandates, restrictions that you all put on these traditional public schools, the worse it becomes, and the better for public charter schools' recruitment and retention, with autonomy being the greatest reason to move out of a big, over-regulated, over-mandated forced placement district into a charter school where you have more control over your results. This is also a decision that is currently in the hands of the Nevada Supreme Court. So I ask that you vote no today.
Any further remarks from the floor? Senator Flores.
Just briefly wanted to remind folk that this bill has nothing to do with teachers. This bill does not address teachers. Just wanted to make that clear.
Any further remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the yeses are 13, the nays are 8. SB 251 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 292, introduced by Senator Pizzino, revises provisions relating to school administrators. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 under Section 1.
Are there any amendments?
There are none. Section 12, this act becomes effective on July 1, 2023. End of bill.
Senator Pizzino.
Thank you, Mr. President. Senate Bill 292 provides that principals are employed at will for the first 3 years of employment, and that after those 3 years, the principal may be placed back on at-will status and subject to immediate dismissal if, in each of 2 consecutive school years, 1, the school's rating is reduced, and 2, at least 1/2 of the teachers request a transfer. If these events occur in any school year, mentoring must be provided to the principal and a survey of school conditions must be conducted. Additionally, the bill outlines certain entitlements of a principal who is reassigned, and the bill is effective July 1, 2023.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 21, the nays are 0. SB 292 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 310, introduced by Senators Goycochea, Hanson, and Stone, establishes provisions relating to dentistry. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 under Section 1.
Are there any amendments?
There are none. Section 50, end of subsection 2, end of bill. This bill requires a 2/3 majority vote.
Senator Goycochea.
Thank you, Mr. President. Senate Bill 310 provides the licensure and regulation of expanded functions for dental assistants by the Board of Dental Examiners of Nevada and establishes an endorsement for dental hygienists to practice restorative endorsed dental hygiene. The bill requires an expanded function dental assistant and dental hygienist with special endorsements to practice restorative dental hygiene and under the authorization of a dentist or a public health dental hygienist license in this state, and sets forth the specific services and procedures that they can perform under certain circumstances. The board is required to adopt regulations related to practice, continuing education requirements for the two professions. The bill establishes certain fees relating to the licensure and expanded functions of dental assistants, which are equal or similar fees that apply to dental hygienists. In addition, the bill authorizes qualified dental hygienists to prescribe and dispense specific non-controlled preventive drugs and other items used for the treatment, and requires continuing education for such prescriptions. The board must adopt regulations to authorize dental therapists and hygienists to administer local anesthesia and laser radiation if authorized by the supervising dentist licensed in the state. Finally, the board is required to submit a report to the legislature not later than January 1st of 2025. That includes certain information regarding the licensure of expanded function dental assistants and special endorsement to practice restorative dental hygiene and prescriptions and dispensing of drugs by certain dental hygienists. The effective date is January 1st of 2024. This bill is about dental techs, and clearly the amendment that came forward, I missed the mark with it. It's really not what is intended. I'm asking the body, it's a 2/3 bill because of the fees required. I believe it's a 2/3 bill. Anyway, support it. Let me get it across the other house. Again, let me provide dental techs and better service for our dentists in this state and our public. The bottom line is I apologize. The amendment wasn't what I thought was going to be coming forward. I ask you to support it and let me get it across and get it fixed. It's a good bill. It was a good bill. And with that, I'll close.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Secretary, close the roll. The yeses are 17, the nays are 4. SB 310 has received a 2/3 vote, is declared passed and ordered to the Assembly.
Senate Bill 321, introduced by Senators Krasner, et cetera, and Assemblywoman Thomas, et cetera, revises the provisions relating to crimes. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1 and Section 1.
Are there any amendments?
There are none. Section 7, end of subsection 2, end of bill.
Senator Krasner.
Thank you, Mr. President. Senate Bill 321, Justice for Victims, Survivors of Sexual Assault. Senate Bill 321 prohibits storing the DNA profile of a survivor of sexual assault unless authorized by federal law, or sharing the biological evidence of a survivor unless required to do so pursuant to a court order as part of discovery, or it is necessary to identify or prosecute the perpetrator of the assault. It is further prohibited to use forensic evidence to prosecute the survivor for any crime or for any other purpose not directly related to solving the crime or apprehending the perpetrator. The bill also requires, to the extent money is available, the Central Repository for Nevada Records of Criminal History, the state DNA database, and each forensic laboratory to conduct an audit of any biological specimen or DNA information it stores or maintains. The audit must analyze compliance with state law on preservation of such evidence and identify the number of DNA profiles that should have been collected in the year 2021, but were not. Thank you.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 21, nays 0. SB 321 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 323, introduced by Senators Severs, Gansert, and Hansen, revises provisions relating to peace officers. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 2, end of subsection 2, end of bill.
Senator Severs, Gansert.
Thank you, Mr. President. Senate Bill 323 requires the Peace Officers Standards and Training Commission to adopt regulations to establish standards for the reciprocity of a person from a state, another state, or the federal government with a certification of law enforcement training equivalent to serve as a Category 3 peace officer in the state. This bill is effective upon passage and approval for the purposes of adopting any regulations and performing any other preparatory administrative tasks and on January 1st, 2024 for all other purposes. Thank you.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 21, nays 0. SB 323 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 328, introduced by Senators Titus and Wynn, eliminating the exemption of the Cannabis Compliance Board from the provisions of the Nevada Administrative Procedure Act. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1 and to Section 1.
Are there any amendments?
There are none. Section 7, this act becomes effective upon passage and approval. End of bill.
Senator Titus.
Thank you, Mr. President. Senate Bill 328 makes the Cannabis Compliance Board subject to the provisions of the Nevada Administrative Procedure Act for the purposes of adopting, amending, or repealing regulations and the adjudication of contested cases. The bill repeals statutes that set forth specific procedures for the board to adopt, amend, or repeal regulations, and revives the procedures for the board to take disciplinary action to conform with the procedure for the adjudication of contested cases. Bill becomes effective October 1st, 2023. Thank you.
Are there any remarks from the floor? Senator Orenshaw.
Thank you, Mr. President. I have a disclosure to make on Senate Bill 328. Because we are considering Senate Bill 328, which directly affects the Cannabis Compliance Board, I would like to again advise you, Mr. President, and the Chamber that my wife serves as an appointed member of the Nevada Cannabis Compliance Board. Seeking the advice of our legislative council, based on that advice, I plan to abstain on this vote and any future votes on Senate Bill 328.
Are there any further remarks? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The ayes are 19, the nays are 1. SB 328 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 352, introduced by Senators Scheibel, etc., revises provisions relating to prescription drugs. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1 and to Section 1.
Are there any amendments?
I have amendment number 503, proposed by Senator Scheibel.
Senator Scheibel.
Thank you, Mr. President. I move to dispense with the reading of Amendment 503.
If there are no objections, so ordered. Senator Scheibel.
And I move to adopt Amendment 503 to Senate Bill 352.
You've heard the motion. Senator Scheibel.
This amendment adds new provisions to authorize certain persons and entities who are authorized to dispense controlled substances and dangerous drugs to acquire controlled substances and dangerous drugs directly from an outsourcing facility.
Are there any remarks on the amendment? Senator Stone. Okay. Any remarks on the amendment? Seeing none, all those in favor signify by saying aye. Aye. Opposed, nay. Motion carries. Are there any further amendments?
I have amendment number 529, proposed by Senator Stone.
Senator Stone.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered. Senator Stone.
Thank you, Mr. President. I move that the Senate adopt Amendment 529 to Senate Bill 352.
You've heard the motion. Senator Stone.
Thank you, Mr. President. Amendment 529 to Senate Bill 352 does the following. Requires an insurer to cover certain contraceptive services when provided by a pharmacist to the same extent as if the first services were provided by another provider of health care.
Are there any remarks on the amendment? Seeing none, all those in favor signify by saying aye. Aye. Opposed, nay. Motion carries. SB 352 is ready for final action.
Senate Bill 352, introduced by Senators Scheibel, etc., revises provisions relating to prescription drugs. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 and to Section 1. There are no further amendments. Section 18 and to Section 18. End of bill.
Senator Stone.
Thank you, Mr. President. Senate Bill 352 makes various changes relating to the dispensing of prescription drugs. Specifically, the bill clarifies that a pharmacy benefit manager, also known as a PBM, who manages prescription drug benefits for an insurer, must comply with the same provisions of the Nevada Insurance Code as the insurer, provides that insurers may only charge an insured a copayment or coinsurance for contraceptive once for the entire amount of the drug dispensed for the plan year or once for each month of drug supply. Requires health Policy ensures to demonstrate their capacity to adequately deliver family planning services provided by pharmacists and to notify insureds of participating pharmacists and pharmacies in the relevant network plan. Requires insurers to provide certain coverage for contraceptive service provided by pharmacists to the same extent as if those services were provided by another provider or healthcare to reimburse the pharmacist for providing such services at a rate that is not less than the rate provided to certain healthcare providers who provide similar services. Requires a pharmacist to dispense a certain number of months' supply of contraceptive drugs, up to a 12-month supply, or another amount that covers the remainder of the planned year under certain circumstances, and authorizes certain persons and entities who are authorized to dispense controlled substances and dangerous drugs to acquire controlled substances and dangerous drugs directly from an outsourcing facility. Finally, the bill requires a contract entered by the Department of Health and Human Services or a PBM or health maintenance organization concerning prescription drugs to require a PBM or HMO to comply with the provisions of the law regarding prescription drug provisions under the state plan for Medicaid and the Children's Health Insurance Program. This requirement does not apply to a contract entered before January 1st, 2024. This bill is effective upon passage and approval for the purpose of adopting regulations and performing any preparatory task on January 1st, 2024 for all other purposes. Thank you, Mr. President.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 21, the nays 0. SB 352, as amended, has received a constitutional majority, is declared passed and ordered to the Assembly.
That concludes Order of Business 13.
Order of Business 16.
Mr. President, we can get just a brief 1-minute recess.
Okay, 1-minute recess. Senate is back in order. We are on Order of Business 16, remarks from the floor. Senator Cannizzaro.
Thank you, Mr. President. A couple of things. Number one, tomorrow, our tourism caucus will be meeting in 3100 at 5 p.m. So would love to have everyone join us in 3100 at 5 p.m. if you are available to engage with the Tourism Caucus. And also a reminder for tomorrow. Tomorrow is Denim Day. As you may know, April is Sexual Violence Awareness Month, and so to honor victims of sexual assault and sexual violence, please wear your nicest denim tomorrow so that we can be reminded and see those survivors and make sure that we're offering our support in that way. And with that, Mr. President, I want to take a moment to thank all of our really wonderful staff who have been here all night with us, working hard and helping to put us on track for today, and appreciate everyone working with us. If we could please give them all a round of applause for our front desk, Sergeant at Arms, fiscal staff, tech staff in the back. They all do such an amazing job. We're very grateful, and thank you for, I know, what has been a late night. I would move that we stand in adjournment till the hour of 11 a.m. on Wednesday, April 26, 2023.
All right, you heard the motion. All those in favor signify by saying aye. Opposed, nay. Motion carries. We are done.